Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. This morning, we have work sessions scheduled on two bills that we had to postpone because we were just simply too busy yesterday. Those are LD 598 and 1946. Before we get to those, we'll do committee member introductions. And then also I wanted to let everybody know that once we have completed our work sessions on those two bills, we're going to have a discussion within the committee about the Maine Commission on Indigent Legal Services and whether we want to report out legislation as we're permitted to do in response to the annual report of the commission and or add budget initiatives. So let's start with committee introductions. I'm just going to call on committee members as I see you on the screen. And Representative Moriarty, we can start with you.
Thank you, Madam Chair. Top of the morning, everyone. I'm Steve Moriarty from Cumberland and the southern part of Gray, which is House District 45.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Libby.
Thank you, Madam Chair. Good morning, everyone. My name is Laura Libby, and I represent District 64, which is part of Auburn and all of mine, and I reside in Auburn.
Representative Sheehan.
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Representative Babbage.
Good morning. My name is Christopher Babbage. I represent House District 8, which is 82% of the voters of Kennebunk, its interior, and just one of its beaches.
Representative Reckitt.
Morning. My name is Lois Reckitt. I am Irish today, and all of the rest of you are as well. I have represent District 31, which is the ocean end of South Portland, as we're all about to undergo a transition, except for the Senate, to new districts. It's going to be a little crazy, but I'm in District 31 today.
Thank you. And Representative Evangelos, we know that you are not able to join by camera today, but could you introduce yourself, please?
Thank you, Madam Chair. Good morning, everyone. Jeffrey Evangelos, House District 91, and I reside in Frenchs.
Thank you. And Senator Sanborn?
Good morning, everyone. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook, although I'm coming to you this morning from the beautiful town of Carrabassett Valley.
And Co-Chair Harnett?
Thank you, Chair Carney, and good morning, colleagues and members of the public. My name is Tom Harnett. I'm Irish every day, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside.
Thanks, everyone. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. I also am Irish every day, and I love St. Patrick's Day, and it's nice that we are together this morning. And then we are joined today by our committee analyst, Peggy Reinsch, and also by our committee clerk, Susan Panett. Thank you all. And now we will open up our first work session. This is a work session on LD 598, an act to prohibit discrimination in employment and education based on hair texture or hairstyle. And we will see if, I believe the bill sponsor is with us. And as is the custom on our committee, we'll bring her onto the panel for the work session.
Good morning, everyone. Thanks for having me.
Welcome, Senator Daughtry. And Peggy, would you like to begin with the bill analysis?
Sure, I'd be happy to. Thank you. So LD 598 amends the Human Rights Act by providing two definitions. One is definition protective hairstyle, includes braids, twists, and locks. And then it uses that definition in the definition of race for purposes of subchapter 3, which is fair employment, and subchapter 5B, which is education. So it's not an neither one of these are exhaustive definitions. They're inclusive definitions. So they kind of start you on the way of here's what's included in these terms. So race for purposes of education and fair employment includes traits associated with race, including hair texture, afro hairstyles, and protective hairstyles. And the way this would work is because it's already prohibited to discriminate on the basis of race throughout the Human Rights Act, but particularly in the education chapter and the fair employment chapter, that discriminating on the basis of those traits by putting this into statute, if someone discriminates in education or employment on the basis of hair texture, afro hairstyles, or protective hairstyles, that would be considered discrimination on the basis of race. You had testimony that this has been adopted, I believe, in 14 states and maybe a couple of other jurisdictions. The Human Rights Commission testified neither for nor against, but they support the purpose, prohibiting discrimination based on different types of characteristics. My understanding is that the Human Rights Commission has been contemplating and is planning on considering rules that would include these things, not as standalone rules, but would be included in the rules. They have not been able to get to those rules yet, mostly because of COVID. And so that hasn't happened. That's one of the reasons why the committee carried over the bill, was to give them an opportunity to go through that rulemaking process, and they have not been able to do that. So the bill is before you, and I'm not sure if you have any questions. I don't have any fiscal information for you yet, but if there's anything else, I'd be happy to try to answer your questions.
Thank you. Committee members, are there any questions for Peggy? Representative Babbage?
Thank you, Madam Chair. Peggy, can I ask, I'm very supportive of the intent. I just wondered if you are aware if where this has been applied, or maybe somebody listening can help me, if the wording has not been more culturally neutral, just, culturally appropriate hairstyles or something like that. I that's the only inquiry that I really have about this. So I'm asking about if, in fact, it's been specific as identified here, or if it's been more generically applied in other statutes. Thank you.
So my understanding, and perhaps Senator Daughtry has more information to this, but my understanding is this comes from kind of a model act that started, this language in particular is adopted from Maryland, but there's something called the Crown Act that it might have more words in it, but it really is focused on protective hairstyles and specifically mentioning braids, twists, locks. Sometimes locks are spelled L-O-C-S instead of L-O-C-K-S. But this is pretty much the standard language for all the states and jurisdictions that I've looked at that have adopted this.
Thank you. Appreciate that. Thank you, Madam Chair.
Senator Daughtry, did you want to add anything in response to the question?
Yes, please, and thank you. And good morning, everyone. Glad to be here with you on this, what I was hoping was going to be a sunny St. Patrick's Day, but sadly in Brunswick is a little overcast. I just wanted to add, everything on there. This has passed in 14 other states. It is coming with from a piece of model legislation, which I am not normally a fan of. I'll be the first one to say that, but it is coming out of a lot of amazing work from a group associated. If you look them up, and I know they submitted testimony as well, they're called the Crown Act. This grew out of a grassroots organization. And especially what's important for me as the bill sponsor, this was something that was brought to not only my attention, but many other members from a group of local women here who have lived through experiences that would be covered under the Crown Act. And so that's sort of where this process went. And the reason, as stated, why it's coming so late is this had been hoped to be done under rulemaking and hadn't been achieved yet. And what was clear from the folks who had brought this to my attention and to others is that they really wanted to see action on this and wanted to make sure that we kept that ball moving forward. And hopefully that helps.
Thank you very much for that additional information. Senator Sanborn?
Thank you, Madam Chair. And thank you, Senator Daughtry, for bringing the bill forward. And I'm a co-sponsor of it as well. I wanted to have Peggy explain, I think that what we heard was that the rulemaking process for this particular type of rule under the Maine Human Rights Act is quite complicated because it has to involve the education department as well. Can you walk us through what that process would have to entail?
Sure. So the employment rules under the Human Rights Act are adopted solely by the Maine Human Rights Commission, but the education rules are jointly adopted by the Department of Education and the Maine Human Rights Commission. So that is a complicated process. It's not too difficult when they're both on the same page, but if they're not, then things really get bogged down. So not only does the Human Rights Commission have to start this process for the education rules, but they have to work with the Department of Education. So even if their rules could get adopted at the next meeting, or I guess we're in March now, it would be the March meeting, it would just be for employment, and they haven't gone through that process for the education rules. So yes, thank you for mentioning that. That is a little bit more complicated process dealing with education.
Committee members, any additional questions for Peggy? Any additional questions for the bill sponsor? Representative Babbage, your hand is up. Did you have another question?
I want to once again apologize, Madam Chair. Thank you.
That's okay. Senator Sanborn?
Madam Chair, I wanted to move ought to pass. I don't think there's an amendment, although maybe we need one for a fiscal note. I don't know if there would be one, but I would move ought to pass. And I guess I would just say that I think because of the complexity of rulemaking and the fact that this is really to put folks on notice, to make clear that something that is already protected under our Human Rights Act is spelled out a little bit more, so that women of color who are trying to ensure that they aren't discriminated on this grounds can have something to reference. And so I don't actually anticipate that this will change the outcome of cases that are actually brought, because I think those women would have prevailed in those cases under our current law. And I think that's what we heard Director Sneerson testify to at the public hearing. But instead, it becomes a tool and a thing that a piece of our law and our statute that can be protective in preventing this type of discrimination, because it's clear to all that hairstyles of this type are protected, and that discriminating on this basis is racial discrimination. And so I urge the committee to vote ought to pass.
Thank you for the motion. Is there a second? Representative Harnett?
Thank you, Madam Chair. I second the ought to pass motion.
Thank you both. Is there any committee discussion on the motion? I'm not seeing any committee Representative Harnett, go ahead.
Thank you, Madam Chair. I just wanted to briefly explain my reasons for seconding this motion and why I will be voting yes on LD 598. I would point out, first of all, I want to thank the bill sponsor for bringing this forward. I think that this is an important issue, and the mere fact that we have not had cases in Maine might actually explain the need for this statute. I would note that we had no testimony in opposition to the bill. I would echo the sentiment of my colleague, Senator Sanborn, and point out that the Maine Human Rights Commission Executive Director, while she testified neither for nor against, did say that she supported the policy embodied in this LD and also indicated that they are engaged in rulemaking. While she said that she believes, as Senator Sanborn said, that this is probably already covered in the law, under the Maine Human Rights Act, what this bill will do is provide clarity to those who might be impacted and might not even know that this is a violation of the law. Having this statute, if it's enacted, would allow them to educate their employer and their educational institution about the fact that these traits are they're racial and cultural traits, and that they are protected under the law. So all those reasons, I will be voting in favor of LD 598. Thank you, Madam Chair.
Madam Chair,
Thank you. Yes, Representative Evangelos?
Not going to make a long speech, but I agree with Representative Harnett's sentiments. And Maddie, my camera's not working, so I can't vote on the screen, but I'm going to be voting yes. I'll cast my ballot later this week. Thank you.
I also would like to speak briefly to the motion. I'm fully in support of the motion. I know that this is a really significant concern. We had hoped that the Maine Human Rights Commission would be able to address it through rulemaking, and that has been delayed. But we know from the testimony of the Maine Immigrant Rights Coalition that this is a serious issue. And because they didn't appear to testify in person, I just want to read a little bit of the testimony before we move on for a vote. The Maine Immigrants Rights Coalition testified that in writing, we often see the impact of race-based hair discrimination in the communities we serve. Black and brown students from our communities have been shamed by their teachers because of their hairstyles. Black and brown children in foster care have been questioned about why their haircuts are so expensive. For decades, hair discrimination has been prevalent in classrooms and workplaces across the nation and even here in Maine. And so for those reasons, I'll also be supporting the pending motion. Committee members, any additional discussion before we move on to the vote? Representative Libby?
Thank you, Madam Chair. No further discussion. I just would like a quick 5-minute corner caucus, please.
Thank you. It is, so we'll resume at 10:30, everyone. Thank you.
Thank you.
All right, I think you get a gold star for a quick corner caucus, or green star today, excuse me.
I did say 5 minutes. Thank you.
Thanks. So it looks like we are back and ready to vote. Representative Babbitt, did you wish to be recognized?
Yes, ma'am. Thank you. I know some people have weighed in on where they are on this, and I just wanted to, mention that in 4 decades of being in the classroom teaching social studies, which not only is citizenship education, but in my case, helping 16, 17, and 18-year-olds understand and navigate American culture successfully. Maine, it is a time when people express individuality, but given the immigrant populations that come to our state, in teaching immigration throughout the American story, generally immigrants want to belong and assimilate, but that is a choice in a free society, and where their choices are made difficult, I think this particular legislation can only do good, and so I will be voting in support in order to reduce any discriminatory action. It's a part of education, and I think this is a helpful piece of legislation. Thank you, Madam Chair.
Thank you. Committee members, are we ready for the vote? Representative Thorne, would you like an update as to where we are?
I have been watching off screen, Madam Speaker, Chair, and I'm prepared to vote. Thank you.
Thank you. And once we finish this work session, we'll let you introduce yourself. Okay, committee members, and our clerk, Susan Panett, has appeared, and you can go ahead with the vote, please.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
I'm present but unable to vote because of my camera.
Thank you, Representative Evangelos. Representative Newell. I will recall the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 2 members voting in the negative, and 4 members are absent. That is the vote of the committee.
Thank you. And for those who voted against the pending motion, could you please let us know what your report is?
Not to pass.
Both. Okay, thank you. Thank you. So the ought to pass motion carries 8-2 with 4 absences. Those legislators will be able to report their votes over the next 48 hours. So with that, we will close the work session. on LD 598 and thank the sponsor for joining us today.
Thank you, everyone. Have a lovely morning and a happy St. Patrick's.
Hey, you too.
So the work session on 598 has concluded. And Representative Thorne, would you like to introduce yourself?
Thank you, Madam Chair. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Thank you. And so committee members will now move on to our second work session, and that is on LD 1946, an act to ensure constitutionally adequate contact with counsel. The sponsor is our colleague, Representative Harnett, and we will begin the work session with Peggy's bill analysis.
Thank you for your patience. LD 1946 is an act to ensure constitutionally adequate contact with counsel. And this bill is kind of lengthy. It has similar provisions for both the Department of Corrections facilities, detention and correctional facilities, as well as the county jails. It requires that it actually prohibits a facility from intercepting, recording, monitoring, disseminating, or otherwise divulging any oral, written, telephone, video, or electronic communications between a resident and the resident's counsel. So the Sixth Amendment requires that indigent defendants have the ability, or actually anybody have the ability to have counsel, and not just indigent. And so there's a Sixth Amendment right to counsel. The concern is that the interception of phone calls or video calls or even written materials is a violation of that Sixth Amendment right. So this bill goes forward to prohibit that conduct, require facilities that are providing communication services to keep logs of any of the communications inside that facility between a defendant or a resident and their counsel. And the Maine Commission on Indigent Legal Services is supposed to have access to audit reports so they can ensure that those communications are confidential and not being intercepted and then disseminated either for investigative or prosecutorial purposes. The jails and the correctional facilities have a need to monitor what's going on in their facilities. So to make sure there's no contraband and to keep everybody safe and that there are no escapes. So there is a reason why some of the monitoring is going on. So this bill requires the chief administrative officer at each of these facilities to adopt a policy that prohibits that interception or the recording. And it defines in prisoners' rights or correctional facility residents' rights the definition of confidential communications, and it includes confidential communications by telephone, video, or electronic communications. It also provides for space for anybody who's a resident to be able to have confidential communications with their counsel in person and to have access to review written records. That works for both the Department of Corrections and the county jails. It also establishes the confidential communications. There has to be an opportunity in the facilities as well as the courtroom, as well as the court facilities for anybody who is part of the criminal justice system. So after they've been arrested or detained or they're arraigned or they're indicted, to have that confidential communication with their counsel whether it's in a correctional facility or a jail, or sometimes it's in the courthouse leading up to those court proceedings. If any of those recordings are, any of those phone calls or video calls are recorded, or if any of the paperwork, any of the documents are intercepted, they may not be used in court, or the information that is in them may not be used in court in a prosecution. The bill also prohibits the participation in court by anybody who has actually had access to those, and access is drafted fairly broadly. If they have access, whether or not the person has reviewed the substance of the document or listened to the call. It also gives an extra ability for post-conviction review for somebody who has been convicted and they realize that their communications had been intercepted, and that might have, although the bill doesn't say it has to have had a material effect on that conviction, it does give them an opportunity to file for post-conviction review of that conviction. There are civil remedies if that interception has happened, as well as a private cause of action. And it creates, the bill in Part D creates the crime of unauthorized eavesdropping as a Class C crime. And it's broadly written. It's a person is guilty of unauthorized eavesdropping if that person, without permission from all parties to a conversation or oral communication, knowingly eavesdrops on, records, or transmits the conversation or oral communication or any portion thereof between a person who is in the physical custody of a law enforcement officer or other public officer and the person's counsel, or between a person who is on the property of a law enforcement agency or other public agency and the person's counsel. So it's fairly broad. And then Part E of the bill requires the Maine Commission on Indigent Legal Services and the Department of Corrections and the county jails to go back and look at what has happened in the past. If you remember, there were some newspaper articles explaining the number and the content of calls that had been recorded and intercepted, and in some cases shared with either investigators or prosecution. That's basically what the bill does. It's got many prongs. There is an interception of oral and wire communications law that prohibits some aspects of this, but not specifically these activities. That was maybe not 30,000 feet, but if you have any questions, I'd be happy to answer them.
Thank you. Thank you so much, Peggy. And committee members, I want to open the floor up for questions to Peggy, but I also want to recognize the bill sponsor. So let's have Representative Harnett speak to us, and then we'll open it up for questions.
Thank you very much, Madam Chair, colleagues on the committee. I have an amendment to this bill that I will explain or have Peggy walk us through. I'm not sure of the process, but I want to explain as to how I arrived at the point that I find myself. The amendment is a resolve to establish the committee to ensure constitutionally adequate contact with counsel. When I put this bill in, on behalf of the closest thing we have to a public defender in the state of Maine, and that is the Executive Director of the Maine Commission on Indigent Legal Services, Justin Andrus. I believe that this is an incredibly important piece of legislation. The confidentiality of attorney-client conversations is one of our most sacred privileges. It is a fundamental constitutional right, and it is absolutely the responsibility of state government to ensure that those rights are protected and carried out. Those rights exist today. They exist whether this bill is enacted or not. As we went through the process as I went through the process of trying to work with the various stakeholders, those being the Commission on Indigent Legal Services, the Department of Corrections, the District Attorneys Association, some of the criminal defense bar, it became clear to me that I would not be able to get a bill, get the best bill through to make, to get a statute out this year in the 130th legislature. So for that reason, I am asking you to support the resolve. And I want to briefly run through the charges to the committee that will be established. And those are to review the constitutional and statutory requirements concerning adequate communications with counsel for those individuals involved in the criminal justice system, to review recent policies and practices that have resulted in the reported violations of this requirement in Maine, review how other jurisdictions through statute ensure confidential communications by telephone, video, electronic communication, or in person between counsel and clients that are incarcerated or detained or in court facilities. To review how other jurisdictions ensure opportunity for document review by those incarcerated persons without interception, monitoring, copying, redaction, or other action, or review by anyone acting on behalf of the correctional facility, jail, or state. To review remedies used by other jurisdictions when the requirements are not met, including but not limited to the exclusion of evidence, the disqualification to participate in a prosecution, licensure discipline, and expanded opportunities for post-conviction review. And finally, develop recommendations to implement in this state to ensure that the residents, the Department of Corrections, correctional and detention facilities, persons who are incarcerated in county jails and other county correctional facilities, and clients in court facilities have adequate counsel, have adequate contact with counsel. The resolve has an emergency preamble, so the committee, which is a balanced committee, can get to work immediately on this. It requires a report out by November 2nd of this year, and it will allow and specifically authorize, it will be a staffed committee, and it will allow the Judiciary Committee to report out legislation in the 131st. It is not the result that I was hoping for, and I know, and I will not speak for him, but I know it is not the result that the Executive Director of the Maine Commission on Legal Services was hoping for, but he has indicated to me that he will fully and actively participate in this process and with this group to try to report out sound and solid legislation. I just want to point out one thing that I think is very important to remember, because as I said, this is not the result I was looking for, but I want to make clear, crystal clear, that this does not suspend or impact the state's constitutional obligations in any way, nor the rights and remedies that are currently available to any and all persons who have been injured by this illegal practice, which has been reported to occur in the state of Maine. So I am happy to answer any questions, but I would ask for your support on the committee amendment to establish the committee that I just explained. Thank you, Madam Chair.
Thank you. Thank you, Representative Harnett.
Madam Chair.
Yes, Representative Evangelos, you're recognized.
Okay, thanks a lot, Senator Carney. Representative Harnett, this is not the outcome I was looking for either. Quite clearly, these activities are illegal, and unethical. I mean, it's just downright cheating is what's going on. And I want everybody just to imagine for a second if an incarcerated individual who has access to computers because of his educational opportunities was able to hack in to conversations between law enforcement and prosecutors. How long would they stand for it? So, you know, Tom, I'll vote for the amendment, but I hate these things, you know. we are encountering resistance to reform from prosecutors. Let's not kid ourselves. They are not on board with criminal justice reform when we get right down to it. And at some point, we're going to have to force this change. That's all. Thanks, Madam Chair.
Thank you, Representative Evangelos. Representative Moriarty, you're next.
Thank you, Madam Chair. I just wanted to comment in response to Representative Evangelos's remarks that I think that if this resolution passes, that the Department of Corrections internally ought to begin to immediately implement some instructions or rule changes of its own to prohibit the recording of these conversations, which are clearly constitutionally privileged. So I hope that no time is wasted in that effort. I also note that there was several days ago another amendment jointly prepared by District Attorney Maloney and Director Andrus. So it appears to me as though the prosecution side of the equation is coming on board, or certainly moving in the direction of reform, having recognized the abuses which apparently are taking place. I was pleased to see the resolution proposed by Chair Harnett last night. I won't speak for anybody else, but there have been many times this session and last session that I have wished that for some of these more complex issues, there had been more analysis preceding the bill, as opposed to input from individuals as persons or individual organizations. It's very useful, but I think a multi-partisan, so to speak, committee can be a very, very effective way of educating us and showing us the path forward. I also, as a final point, want to remark on the emergency clause. I understand that may possibly rub some folks the wrong way, but in these complex cases, the Constitution puts us in a conundrum in that bills don't take effect until 90 days post-adjournment. It's better in the second session than in the first, but the underlying problem is that we, well, on the one hand, we are paying for staff support. The committee often doesn't have enough time to meet its report deadline, and both its time and the taxpayers' money is wasted. So that, to me, is sufficient grounds to find an emergency. It guarantees as closely as possible that the assignment will be completed by the deadline that we have established and that the time will not have been wasted. For these reasons, I certainly support Mr. Harnett's proposed amendment.
Representative Harnett?
Thank you, Madam Chair. If I might, could I offer brief comments on Representative Moriarty's statement? Again, I want to make clear, and at the risk of repeating myself, that much of the behavior that was discussed in the original statute is illegal, is unconstitutional, and that does not change. The state has constitutional obligations, and those rights are enjoyed by all persons in the criminal justice process. I do believe that both the reporting in the main monitor and the public hearing on this case has made it very clear to the Sheriff's Association and to the Department of Corrections that there is a problem. And there was nobody who denied the problem, nor was there anyone who said that we do not need to fix it. I do believe there is commitment to work on it. So I think that all parties are on notice that this is occurring and that this has to stop. Thank you, Madam Chair.
Representative Babbage?
Yes, thank you, Madam Chair. I'm profoundly disappointed with the turn of events, the fact that we're not allowed to get to the finish line on this particular piece of legislation, which is very significant, and I really want to commend the sponsor and the folks that put the time in to make this happen as far as it went. I'm also disappointed that in shoring up our constitutional rights, that when this report comes out of committee, which I certainly hope we're able to do in an emergency fashion, that I'm disappointed that I will not be part of this committee, this wonderful committee, in deliberating its report. So I just want to commend the good House Chair for bringing this forward and for all of his efforts. And I understand the motion before us, which replaces the bill, but once again, not getting to the finish line is hard to swallow when you're talking about constitutional rights. So thank you very much.
Representative Libby.
Thank you, Madam Chair. I support this motion, and given the tight timeline this session, I agree there was not adequate time to work this bill. I very much appreciate the sponsors understanding that and switching gears to ensure that we can address this important constitutional issue. I'm not generally a fan of resolves or committees, but I think this amendment gives a really well-rounded group, and it's not highly cumbersome with several dozen, but instead a group of 15, which I think will be nimble enough to get the job done. And I also can appreciate the desire for a timely report, given the nature of what this is dealing with. And so I do support the emergency preamble. Thank you very much, Representative Harnett.
Committee members, any additional comments? Just have one brief, Peggy wants our attention. Let me make a brief comment and then I'll turn it back over to you, Peggy. In addition to, and I appreciate the expressions of support for the emergency provision, because I think that's important, we will also have to prioritize and advocate this for funding as a study. And so I just want committee members to be aware that that is an important part of our advocacy to address this issue. And Peggy, go ahead.
I just wanted to clarify something Representative Moriarty said about it looked like there was an amendment that was worked on and approved by both Megan Maloney and Justin Andrews, and that was my fault. It had not been approved by both. They had been working on it. I received it from one and thought it was from both, and it was not. So that was my speeding ticket that day. So that was actually just from the district attorney. So it's not like we're moving backwards. I thought they were moving faster than they really were. So I just wanted to clear that up on the record, that was not an agreed to amendment. So you have it in your file. It has both names on it. If you could cross out Justin Andrus's name on that, I would appreciate it. That was my fault for moving a little bit too fast, a little too hopeful there. And I have an updated draft if Representative Harnett wants to go forward with that or not. I don't know.
Yes, Peggy, you can explain there's an addition to the roster.
Right, and I have great trepidation in doing this after Representative Libby said 15 was a good number, because the Commissioner of Public Safety would like to be involved in this as well. And the governor's office thought that was a good addition. So it would actually be 16 members if that's not a problem. And I can screen share that with you. I decided not to email you this morning. You didn't really need one more email from me, but I'm happy to show this to you if you'd like.
Thanks, Peggy. Committee members, does anybody need a screen share for the addition of the Commissioner of Public Safety to the committee? Okay. All right. Thanks, everyone. Any additional discussion on the motion? Not seeing any. I think we are ready for the vote.
I don't believe we
There's
have.
Hold on. We have Representative Harnett. You're recognized. Go ahead.
I don't believe we have a motion yet.
Oh, that is a very good point. Peggy, you can hand your speeding ticket over to me. I'll take care of it. Committee members, it looks like we've we're complete with our discussion. Is there a motion? Representative Libby.
Thank you, Madam Chair. I'd be happy to make a motion to, an ought to pass as amended motion with the addition of the public safety
Commissioner.
Yes.
Thank you. And Representative Moriarty?
That was the motion I was going to make. I will second it.
Okay, so motion by Representative Libby, seconded by Representative Moriarty. So that I won't get another speeding ticket, is there any committee discussion on the pending motion? I am not seeing any. Is the committee ready for the vote? It appears that we are, and Susan Panett, our clerk, has appeared. You may call the vote.
Thank you very much, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent. That is the vote of the committee.
Many thanks, Clerk Panett. So the pending ought to pass as amended motion prevails 10-0 with 4 absences, and those absent committee members will have an opportunity to vote over the next 48 hours. And with that, many thanks to Co-Chair Harnett, and we'll close the work session on LD 19. I'm not able to come up with the number right now, 1946. Thank you, committee members. And that concludes our 2 work sessions for the day. But I did want to open up the floor for a committee discussion of the Maine Commission on Indigent Legal Services report back on some, well, the annual report that they have provided to us. We did hear from the executive director, who's not available today, with regard to some requests for budget initiatives. And let me just check to see if, yeah. And so at this point, I would like to initiate a committee discussion related to the Maine Commission for Indigent Legal Services, since our budget report is due today, but we do have an opportunity to add initiatives related to the commission, related to indigent legal services. Would anybody like to start off our conversation? Representative Moriarty?
Thank you, Madam Chair. Just to get us going, I wonder if there is a document that Peggy might screen share, which lists out Mr. Andrus' recommendations. I know I could probably find it, but that would take some time.
That's a great suggestion. And Senator Keim did request from Justin Andrus an outline of the proposals along with some cost estimates. And Peggy, would you be able to share that with us, please?
I should have been on top of this and pulled them up, and I didn't. So that's what I want.
That's okay. Unlike
Okay.
most days, we have a little wiggle room today.
Great. So is this what you were looking for? This was Senator Keim had asked Director Andrus some questions about specific things that he had mentioned, and he put together a lot of information for her. Is this the memo you're looking for, or was there something else? He had also presented as part of the commission packet a lot of information about all the statutory changes that he thought might be necessary, in some other ideas. I think some of his ideas weren't actually in writing until he put this together. So this, I believe, has what he calls the flying squad, that deployable unit. And it breaks down all the salary, ancillary costs. And I think this is this is the net amount for his flying squad. Is this the document you think you're looking at? Is this what you want to talk about? Or I can look for some other documents that he's given you.
This is the one I had in mind, but let me check with Representative Moriarty. Representative?
Yes, I think it is the very one.
Okay.
No?
All right, and then all right, so let me back up and just say, to committee members, does everybody, it's not been very long since we heard from Justin Andrus, but committee members, does everybody recall his proposal for the flying squad, so to speak? Does anybody need a refresher on what that is? Does not look like we need the refresher. All right. And so Peggy, I think that was on page 7, and I was just, is page 7 the total cost for this particular program?
I think you're right.
Okay.
That is right.
Okay. And we have a lot of committee members, we have a lot of backup information in the memo that precedes these numbers. And while we have the document screen shared, let's just start with if there are committee member questions or discussion that requires reference to the document, please raise your electronic hand. Okay, I am not seeing any. And so Peggy, if you could end the screen share. Thank you. And so committee members, I'd just like to open this up for a discussion of whether we want to include this particular initiative, which I believe was Justin Andrus's top priority, if we want to include this as an initiative in our budget report back. Representative Moriarty, go ahead.
Madam Chair, were there 4 recommendations all told?
I believe there were, and we could take them as a group. We can go through each of them rather than discussing them one at a time, if you'd prefer.
Well, it would just be helpful to me just to have them listed out without analysis so that I can get a feel, just refresh on how many there are and what the topic areas are.
So in this memo, Senator Keim had asked Mr. Andrus about 4 things. One was this flying squad. The
Right.
second was legal resources. These are all things that he had raised as things that would be very helpful. Training, and that is MCLS paid for training. And then if he had provided some information for that in this memo. I had asked him later about if they paid the hourly rate for attendance at these as well. And that's a different number that's not in this memo. And then the last one in this memo is the contracts to the specialists. the diversion and mitigation specialist, appellate assistance, mentoring new lawyers, and available co-counsel or counsel with a new attorney. And each one of those contracts, he would think would be about $60,000 a year. He thought those would be really, really helpful. So those are the four: flying squad, legal research materials, training, and then his contracts with specialists. There were other recommendations that he had, including raising the hourly rate to $100. And I'm trying to think what the others were. And there's always the Kennebec County Public Defender Office. And there's also kind of renaming the whole activity as the Office of the Public Defender.
Thank you, Peggy. Peggy, could you also, just because I think we're all kind of making lists, can you give us kind of the bottom line dollar amount on each of those 4 items?
Oh, sure. I think I can. So if you remember the chart that we just showed, that was about $1,050,000 a year. So 2,100,000 for a biennium. The legal research, I'm sorry, based on 300 attorneys, he thought that would be about $230,000 a year, everything that they were asking for. I believe that's it. The training, he estimated that it would be a total of $300,000. So 4 events that would cost a total of $250,000 for the space and whatever food that they provide at those events, as well as about $50,000 for the actual teachers. And so that'd be $300,000 for item 3, and item 4, the contracts to specialists. He estimated those contracts at $60,000 each, and 4 contracts, so that would be $240,000. So sorry I went so fast, and now I see both Senator Keim and Representative Angelos.
Great. Let's start with Senator Keim introducing herself.
Good morning, everyone. Oh, happy St. Patrick's Day. My name is Lisa Keim, and I represent Senate District 18, which is Northern Oxford County.
Thank you. And we've also been joined on camera by Representative Evangelos, who was only able to be by audio earlier. Representative Moriarty, so we've gone briefly over the 4 items. We have an idea of what the budget impact would be. Did you have anything that you wanted to initiate by way of discussion?
Let's see. I guess if I were to, first of all, I recognize that all of these recommendations are made professionally and in good faith, and with a view toward accomplishing the constitutional mission. As a matter of practicality, I think we're faced with some harsh economic realities, and what will succeed and what will not. Looking at the list, I would sort of instinctively say that the flying squad, the training, and the increase in the hourly rate appear to me to be the most important.
Thank you. Senator Sanborn?
Thank you, Madam Chair. I guess I would say that the item that that Representative Moriarty left out seems to be a critically important piece to me. The idea that we're not providing sort of bulk legal research access to these folks is like asking them to do their jobs with their hands tied behind their backs. I can't imagine practicing law without access to legal research tool online. And the fact that you have to pay for it yourself just eats into that $80 an hour and further disadvantages our defenders versus the DAs who get this sort of thing for free without even thinking about it when they walk into the office, or now at home when they don't even walk into the office. So I feel really strongly that we should add these to our budget recommendations, that we should write them up as initiatives, that we should make it very easy and try and have them sort of formatted the way that the budget is formatted, so that they could be enacted as individual initiatives and voted in by the appropriations committee. And I would ask that they be listed separately, right? Each of them would be an item, a line item initiative in our report back. So that would be my suggestion. I have a suspicion that the flying squad may need to also be reported out as a bill. That seems more like a new initiative that would require statutory language, not just funding, because it's a concept that doesn't exist currently. But I think something like legal research and training could simply be line items in the budget. So that would be my suggestion to the committee. I think I want to differ a little bit with Representative Moriarty when he says we're in a grave financial situation. I think we're actually in a situation where our revenues are much higher than was anticipated for this budget cycle. And while that may not always be true, there may be headwinds in our economic recovery for sure. I think the total dollar amount that we're talking about here is incredibly small. And the Sixth Amendment implications of the way we have structured our system of indigent legal defense, I don't think anybody on this committee thinks it's okay. So I think this is a situation where we really have to come with a united front to the Appropriations Committee and ask for some of these things in the face of what I think is a pretty well-founded lawsuit against the state of Maine for Sixth Amendment violations that we've been anticipating for a number of years. Thank you.
Representative Evangelos.
Thank you, Madam Chair. And I won't repeat it, but I want to echo Senator Sanborn's sentiments and the good idea about this separate bill in that one area of the squad that could help fill voids. I was in the process of switching computers and I missed part of what Peggy put up. Is the $100 an hour in there, Peggy?
No.
Okay, so I'll get to my list in a second, but first of all, I did read the document that Justin sent, and then I missed part of the screenshot to remind me. But I want to ask the attorneys on our committee a question. Any of you who attended the session on December 9th, we identified some pretty serious deficiencies where there was such an imbalance of power between the prosecution and the defense. Do the stipulated improvements that Mr. Andrus has listed, are they, in your opinion, going to address those deficiencies? Are we filling that void, paralegal, other types of help? I just want to hear from you as lawyers whether you're satisfied with filling that void.
Would anybody like to go ahead, Representative Moriarty?
Thank you, Madam Chair. I just grabbed my MCILS file and I'm not immediately seeing notes from a December meeting. And I don't have it written on the jacket either. So Representative Evangelos, I'm not finding what you're
I'm sorry, it was Maine Indigent Legal held a forum whereby 150 or so attorneys and certain justices attended. We were all provided a notice of it as members of the committee, but it wasn't a committee meeting. We were just guests watching it. We were allowed to ask questions and make statements. I'm referring to a list of grievances that those attorneys that day provided us as to how unequal the justice system is, that the, for instance, in the prosecution or attorney general's office, I'm trying to be brief here, they provided all kinds of ancillary support, but in the case of an attorney serving the indigent legal system, they're taking it out of their $80. So I'm asking, I know Senator Carney and Representative Harnett watched part of it or all of it. So I'll direct the question to them. Does the list that Mr. Andrus provided, is that getting us there?
Thanks, Representative Evangelos. And Representative Harnett's hand is up, so we'll let him answer. And then I would very much like to answer your question as well.
Thank you. Thank you very much, Madam Chair. Thank you, Representative Evangelos, for the question. And I don't think I need to be a lawyer to answer it. I did sit in and listen to that entire hearing. And I think the short answer to your question is no, it does not address all of those concerns. These are steps in the right direction. But what we have heard from the Executive Director of the Maine Commission on Indigent Legal Services is that we will not have truly adequate attorney representation until the day that the public defender is funded, public defense is funded in the equivalent manner or the equivalent amount to the prosecution. Some of these issues are addressed in, and I think the Executive Director Andrus would recognize that this does not get us all the way. It gets us part of the way. We heard a lot about not just salaries, but the benefits that assistant district attorneys and assistant attorneys general receive, health benefits, retirement benefits, vacation benefits. That's not in here. We heard about things like loan forgiveness that you can get when you work for an organization. There are some reasons that that's not in here, but it's not. And, you know, I wished I had my notes in front of me from that meeting, but from what I recall, my answer to your general question would be no, it does not get us there. It moves us to a better place than where we are today, though, or it would. I hope that helps.
And I attended that meeting as well. I thought that the imbalance and the impact of that imbalance on the attorney's ability to represent their clients was palpable. I could feel it as though I were in the room with them. I appreciate and completely accept their representation that there is an imbalance that inhibits their ability to provide constitutionally adequate counsel. I personally, and I've been thinking about this a lot, I think that the best path forward would be to have a statewide public defender office, but to also maintain the ability to refer cases to counsel. I come to that from a couple of different perspectives. I think that some cases require such specialized assistance that it's important to have the ability to refer cases to specific qualified counsel. I also had conversations with attorneys in Aroostook County a couple of weeks ago where they were talking about how the current system in some ways, although there are barriers that make it hard for rural attorneys to participate in the indigent legal services system, that it also serves as a pathway for attorneys who received training in Portland at the law school here in Maine or in other places, that it serves as a pathway for them to return to the rural communities where they grew up and that they love, and to start to build a practice. And that seemed to me like a really important component and something for us to maintain and to build on. But at the same time, my overriding concern was that there simply aren't the attorneys in every part of our state to provide the kind of representation that is required under the Constitution.
Thank you very much for that, both of you. I have several other things? Is it okay if I continue? Get rid of the brief ones anyways?
Yeah, let me just check in and see if there was anybody else who was present at that meeting in December who wished to weigh in, because it was a really important meeting. Does anybody else want to comment? Representative Babbage, were you at the meeting? Okay, no. Senator Keim, go ahead.
Yeah, I was also at the meeting, and I think what I heard almost more than anything else was about the e-filing, which I think the court also heard and has addressed, but that seemed really high on the list for the attorneys that showed up, and feeling disrespected by the courts because of the scheduling issues. And that, I think, is something that we as a committee should be following up on both of those, checking back in to make sure that, I mean, there's somewhat obviously a cost to both of those things, but they're also something that we could just keep checking in on and giving weight to the issues by our voice as well. So those two things really stuck out to me as something that got mentioned by almost every person that spoke. And so I think they're fixes that are more easily attained than some of the other issues that obviously need to be taken care of.
Thank you.
Even asking, I think, for an update from the court on how scheduling and e-filing is going, at a certain time, I think would be appropriate for us.
Thanks. Representative Evangelist, we'll turn the floor back over to you.
Okay, thank you. First of all, when I spoke to the forum that day, I mentioned to them and to everyone that we can do this, we can fix this. At the time I was quoted as saying we're sitting on $800 million. Well, Senator Sanborn's correct. Now we're sitting on $1.2 billion. And so this is not a matter of money. It's a matter of, the will to fix these deficiencies. I think the committee should spend some time to try to make up some of the differences that Senator Carney and Representative Harnett just laid out. And specifically beyond that, I would like to have a committee bill that pays them $100 an hour. Justice Alexander made these recommendations to us. And $150 an hour, if possible, for these homicide cases. We need to tackle health insurance. It's not fair that they have to buy, it's 15 grand or 20 grand if they've got kids. And the prosecution in the state pays health insurance. How are you supposed to pay 20 grand when you're making 80 grand for a salary? We're going to attract attorneys to the system if we improve the benefits and money. And sometimes the youngsters coming out of law school, it'll be an opportunity for them to initiate a new career. And Representative Harnett's right, it should be in a public defender's system. But if we're going to put a bill together and go for it and address the reforms so that, everyone watching us takes us seriously, student debt has to be in it. Justice Alexander said that we're doing it for veterinarians. To attract people into the profession where there's a forgiveness program. I think if somebody signs up for indigent legal for 5 years, like a contract, then they'll qualify for the debt forgiveness. We don't want somebody getting it paid off and then they scoot. So there has to be some kind of a commitment to the system. But these are areas I would like addressed in a bill. And obviously, because of the hearing that's going on today, we're going to need some professional help too from Mr. Andrus. But I think I don't want to talk about this and then we don't at least put the proposals up. Senator Sanborn mentioned separate bills. I don't know how we're going to cobble all this together, whether it be a couple of committee bills. I'm not going to be fearful of the cost when the potential cost of losing a class action lawsuit could run into a lot of money. If we can't get the support of the legislature and the chief executive, then they have to live with it. We have to live with whether we tried to fix it. And Senator Carney's right. Anybody who listened on December 9th realized we're in a really, really bad place. So I want to address the pay, the benefits, the student debt, and lastly, Representative Harnett, what's the status of the public defender proposal? Is it stuck on the Appropriations Committee, or should we make a better pitch with a different type of offering on that? Thank you, Madam Chair.
Would you like me to respond, Senator Carney?
Please do.
And I would check with Peggy, but my understanding is the geographically limited public defender bill that we approved last year remains in AFA. Is that correct, Peggy? So it's there. I don't know what we gain by enacting that again or moving that forward again. But much of the AFA process, I will readily admit, is a mystery to me.
Well, are we satisfied with just leaving that there as our first gambit on public defense, or should we put a new proposal up? I mean, these are things to think about, right?
It's something to think about. That was the proposal that was put forward by the executive director as what he thought to be an initial and important first step to study it.
And Madam Chair, presumably we are going to have one more meeting to finalize all this with Mr. Anders present, right?
Absolutely. This is really our time to discuss as a committee, but between amongst committee members, because we really haven't had this opportunity to have a really in-depth conversation just among us. And I did want to note that we can certainly, once we identify the initiatives that we want to advance, we can also prioritize them, and we can loop back in things that are currently on the appropriations table and rank them accordingly.
Okay, and anything that would need separate pieces of legislation, we can discuss that as well.
Absolutely.
Okay.
Representative Evangelist, I just want to check with Senator Sanborn to see if she was responding to your comments on the issues that you just raised before.
I'm done, so I'm gonna, we'll recognize her right off. I just, it's good to know we're gonna be taking these things up. Anybody who listened to the December 9th, it sort of gave us the list of what we need to fix. So thank you for hearing me out, and I'll look forward to the next meeting.
Senator Sanborn?
Thanks, Madam Chair. Yeah, I just thought it might make sense to loop Peggy in terms of, I had made a suggestion, although I'm not aware of what the timing is for our report back to AFA, but I had made a suggestion that we sort of scramble to try and, put some things that were in sort of budgetary language rather than sort of separate bills. I fear that if we don't get it into the budget as it comes out of AFA and in the sort of package fashion, it's not going to be easy to get the stuff off the table. And so my first gambit is to pick up on Representative Evangelist's word, gambit. My first gambit would be to see what we can do to sort of make it super easy to plug and play into the budget various line items as separate initiatives for funding. So that was sort of my first question to Peggy, and then I guess then I would say to Representative Evangelist that then I think there may be items that we may also want to report out of bill. So we've got something that is on the table that we can have a public hearing on and vote on. And it strikes me that if the question is the limited geographic public defenders the best we can do, that bill the answer might be no. Let's also put a bill on the table that's this flying squad concept, which is sort of another initial effort to get to public defenders, at least in a different paradigm, I guess, than the pilot project for a single county public defender. So we could put that on the table next to the kind of a county project. So that would be my suggestion. And so I wanted to hear from Peggy on whether it's possible to sort of try and communicate to AFA in a way that would initiate budget initiatives rather than bills.
Great. So I think that makes sense. Your report is due today, actually. And so the language I drafted was that the committee's asking for some more time on the MCLS aspects, and that is what we've done in the past. I'm looking at the report back schedule, and it looks like other committees, the last report back is Tuesday, March 22nd. So what that means to me is that appropriations probably will not be starting to work on all these report backs right away. So you do have some time. I would suggest that you go ahead and send in your report that you're done with, and then send a supplemental report which itemizes what you decide you want them to consider as part of the that you want as part of the budget. And just because you're recommending them as part of the budget, that doesn't mean you can't also have them printed as separate bills. That having them printed as bills gets out there in front of everybody. If you're not bringing them back to the committee, because you're probably not going to have time to do public hearings on them at this point, they will just get referred to appropriations if they're enacted in the House. I have to go through those before they go to the table. Things have to be enacted in the House. So you might want to figure out how you want to weigh that. Make sure your items are in front of appropriations one way or another.
Thank you. And I did also want to put into the mix here that we can also request, and I don't think the timeline has passed, although I could check on that. We can request to present these initiatives to the Appropriations Committee as well. I don't feel like we necessarily need to do that with the other budget report back, but with this segment, we may very well want to do that. Representative Babbage, go ahead.
Thank you, Madam Chair. May I ask about the December 9th meeting? Was that an in-person meeting, or was it Zoom, or was it both?
It was a hybrid meeting that the Maine Commission on Indigent Legal Services convened. I want to say most of the attorneys that testified were doing it remotely, but in the room, I think both Representative Thorne, Representative Libby, Representative Harnett, I'm not sure who else. I was only able to attend for about an hour, but there were also people from the judicial branch, Chief Judge Mullen from the Justice Mullen in the Superior Court. I'm trying to think, was it Judge French from the District Court? Anyway, there were representatives of the judicial branch there, and they definitely got an earful, I think. But if you've been in appropriations, when they do a hybrid meeting, they have two giant screens, and so that's where the attorneys were talking about their experiences, and it must have lasted, yeah, at least 4 hours. It might even be posted on their. I might have a link to that.
Well, I was not there. I did have out-of-state family commitment and was disappointed that they fell at the same time. I was wondering if at that time I was anticipating a post-Thanksgiving surge of Omicron, which had just started at that time, and I was a month too early when the surge went exponential. But that must not have been a factor as well. I was out of state and missed this meeting. But the reason I'm raising my hand here is that I appreciate Senator Sanborn's comments. I thought Senator Carney's comments about a public defender office with options to, I think that's with options to have a contract counsel is hopefully where we can get at some point. And certainly Representative Evangelos's comments about our responsibility and where we should go. What I wanted to really say is Mr. Andrus's brainstorming as to what could make his office effective included, 4 specific things that I think we need to be very strongly behind. The 4 of them together: the flying squad, the training, the contract specialist, and the the legal research, to West publication, $700 an attorney or whatever. Those are four things that combined will cost us, less than $2 million annually. So I guess the 2.1 million for the flying squad, is that right? Is a biennial. So given priorities, I do believe those are inexpensive but profoundly impactful changes that would improve the quality of our delivery of public defense here in Maine. A question I had, and I'm sorry, I don't have some of my information in front of me. Peggy, do we have a fiscal consideration for the increase to $100?
Yes. I asked him that and he sent that to me, and I wonder if I can find that.
I know it's much more significant, but nevertheless, all of those are priorities of mine, and certainly Justin Andrus's 4 points are, I think, imperative for us to be very strong on. Thank you.
I'm sorry, I'm not laying my hands on that number right now.
Okay, thank you.
Maybe I actually printed it. That would be a miracle.
We'll find it because we'll have to. I think the principle rather is an important consideration, and we'll fill in we'll get the detail on that soon. Thank you, Representative Babbage. Representative Moriarty? We're not able to hear you, Representative.
I'm so sorry. I began by saying I don't want to lose sight of the rate increase. I'm looking at my notes from the work session we held with MCILS on March 1, and Mr. Andrus said that parity is the #1 priority, and that would mean an increase in the rate up to 150. Although 100 would be a step in the right direction. So I think that still remains a very big priority for them and an obligation on our part. I just want to make a couple comments on things like health insurance and student debt relief. And I'll go back to my own experience. When I began in Brunswick, I did a lot of court-appointed defense work, as Justice Alexander mentioned when he was here with us once. And all of us in the Bath Brunswick area who did it never did it full time. It was simply part of what we did. We also did retained criminal defense, retained family law work, civil litigation, and other types of work, bankruptcy and so forth, which generated income. So I'd be, unless a practitioner were to commit to doing nothing but public defender work, I'm not sure that we have an obligation to pay that person's health insurance and student debt issues if that same person has other sorts of income coming into the office from different types of legal practice. Different thing altogether for those who do it 100% of the time. And I think there's a distinction that needs to be made there.
Thank you, Representative. Representative Reckitt?
Thank you. Mine's a really simple suggestion on the whole issue of what is it going to cost to go from 80 to 100. Reality is all we got to do is figure out what 80 has been and multiply it by 1.25, and we'll be have a reasonable estimate rather than to kill ourselves trying to get an exact figure. I mean, we're talking about a 25% increase. Then that's all you got to do to give us a ballpark figure.
I actually, I think that's what Executive Director Andros had done, because he gave me this information. So if you remember that it went from $60 to $80, so his fiscal year 22 numbers are a mix, right? So MCILS paid out $13,949,290 in fiscal year 21. That was $60 an hour. If you shift that to $80 an hour, that would be $18,599,53. And if you shift that same to $100 an hour, it would be $23,248,816. So that's the total. If you're paying $100 an hour for the same number of hours that were paid out in fiscal year 21, if that makes sense. So you never know if it's going to be exactly the same hours, but using past information and raising the rate, that's what he estimates you'd get.
If I could just add one other thing, Senator Carney. In terms of my own personal priorities of this package of things, to me, the flying squad is the primary thing. I mean, I think that we're talking about dealing with an area of the state that we know has a paucity of attorneys. And I'm really concerned about trying to provide legal services in the areas of the state where there is not, a lot of attorneys that, if they chose to, could do this work. So that's my primary priority. I am also sympathetic to the rest, don't get me wrong. But I think in terms of who's being left out of the ballpark, I think it's the rural areas of the state that are in particular trouble.
Thank you, Representative. Representative Evangelos? I don't know if you're speaking, Representative Evangelos, but we're not able to hear you.
Sorry.
Okay.
I was thinking about one of the things Senator Sanborn mentioned, and I'm going to be as brief as I can, but it may about separate bills if we need bills, rather than do one bill like an omnibus where we go for everything in that bill. If it doesn't make it, we'll lose everything. We might want to have separate bill initiatives. Secondly, having managed towns and schools, I am by nature fiscally conservative, but I am observing around me, there are people that are thinking big and going big. $30 million proposed for the lobster industry, $100 million proposed for cleaning up our soils. So with an additional $400 million surplus, I'm going to join that bandwagon. We need to get our share. Those are serious problems also, not minimizing them. But this is a constitutional crisis. So I just wanted to point out that if some of our requests seem large from what we've done in the past, look around us. Those are larger. Lastly, a couple of people have written me. I don't speak for the chairs, but I think the attendees have some hands up, and I don't know if we're doing attendees today. That's all I have.
Thank you, Representative. And this is the first time we've been able to have a conversation just among ourselves as committee members, and I wanted to make sure that we all shared our thoughts and had a chance to speak with each other before we heard from the attendees, but we will do that in a moment. Thank you. Senator Keim?
Yeah, I just wanted to ask Peggy a question, but also just share my view. I mean, when we had Director Andros in front of us, we asked him what his priorities were, and he gave us these 4. And I personally, I don't know, I guess this is my question to Peggy, but I would love to come out, and I'm not speaking for anyone other than myself, but I would love to come out with a unanimous report on at least these 4 things, because I think that the prioritization has changed, but as I think his experience has evolved, and MCILS has evolved, right? There's been a lot of changes and improvements made. And as Director Andrus gets more comfortable in his role and gets more knowledgeable as well about what's happening in the system, as there's been changing so rapidly, this is what he gave us for priorities. So I don't know how everyone feels about separating things out, actually, as Representative Evangelos mentioned, but if there's a way to do that, I think we give a strong signal. And then I guess, Peggy, all four of these items, even if they were together and we did them, as Senator Sanborn mentioned, just as budget items, do they not need to be in a bill as well? Because they aren't budget proposals that have come from the governor. So I guess in the past, I've always seen us, put it into a bill form, but that's cumbersome right now. So I guess I'm just asking how you would guide us on sort of looping them all together versus separating them out. Just that question.
I think those are questions that I probably can't answer, but I don't think there's a problem offering additional initiatives to the budget directly rather than taking them into bills and going through the House and the Senate, because that will take longer to get them to the table anyway. And there were two things that were not included in the governor's budget that you have included in this report, or at least the majority is included in this report. So that's not an odd thing. And you do have a bill sitting on the table. How you package it to get it through the whole system, I'm not sure. That's not really my where I can help you, but I can help you put together whatever it is you want to put together. I think it makes sense to have all your recommendations ready to go to appropriations if they're money. If you need language, you can amend. There's language in the budget, they can add that in. And very often there will be bills that are on the table that from other committees that they pull into, part QQQ. And so I don't think that should stop you. I just don't know if there's benefit to having a separate bill or separate bills going through the House and Senate and having other people understand what the issues are.
Mm. Thank you. That was helpful.
Committee members, and I'll recognize you in a moment, Senator Sanborn, but I think following up on Peggy's comments, maybe what I think would be really helpful for us today is to focus on the content. And if we can all talk about the content, even if we don't each of us agree on every specific element of it, if we can set out the content, and then we'll have a couple of days between now and when we meet again to figure out how to exactly package that content for a report back on the budget. And so I would like to guide us in a discussion of the elements that we want to be the content, even if there's a little disagreement among them. And then I'd like for us to hear from two people in the attendee part of the meeting who have been waiting to speak with us. Does that sound like a good process going forward, committee members? Everybody okay with that? Okay. Senator Sanborn, did you wish to be heard before we move into that direction? Okay. All right. And so I can't read my own handwriting, but I'm going to give it a shot. The initiatives that we have, and we'll start with, these were the ones articulated, as I understand it, from the executive director, the quote, flying squad, funding so that attorneys representing clients through Meikles have access to online legal research at no additional cost to themselves, a training program, and then contracts for specialists that are necessary, sometimes in defense cases, but not all the time. And again, that's a way of reaching some kind of parity. And then in addition to those priorities indicated by Justin Andrus, the fifth priority would be the changing the hourly rate to $100 an hour. And then the sixth one would be, is there a way to assist attorneys on the panel in obtaining health insurance at a lower cost or some kind of a supplement? The seventh would be, is there a way to provide student loan debt to those who participate or represent defendants through MECLs? And then I think the eighth would be a proposal to bring the hourly rate up to $150 an hour. And please raise your hand if you want to modify, adjust, correct, or add to that list. And Peggy, we can also start with you if you think there's different, okay. Representative Evangelos?
Possible modified public defender expanded.
Thank you. Anything else, committee members on the list? Okay, I'm not seeing any hands up. At this point, I think since we've got our list, it maybe makes sense to hear from Robert Ruffner and Robert Cummins, who are both in the attendee part of the meeting. And I'd like to bring them on to address us briefly, if that's okay with committee members. Representative Evangelos?
I was just going to mention, I like legislating this way. Just tell me to bring my list in and can ask for anything I want. But anyways, no, I think you stated it well. Thanks.
Okay, and so let's hear from these two individuals, and then we'll have some follow-up committee discussion. We'll just give it one more minute for Robert Cummins to join us. And because he's had his hand up the longest, we're going to let him go first. Let me just check to make sure that he's able to. Robert Cummins, are you able to activate your camera and address the committee?
Well, I thought it was working, but apparently is, and I'm in my office. I don't know what's going on. Sometimes this thing, let me see if I can, here we go. There we are.
Oh, wonderful.
Thank you. I consider it quite a privilege to be able to comment this morning. It happens to be my 89th birthday. So, and I am an Irishman. So it's a particular privilege, and I really think of this as a present because, as you know, and I'm not going to bore you with all this stuff I've said before, but I've devoted 6 decades to this business of representing indigents and making sure that the justice system works correctly. Only 5 or so of that has been in Maine. I know the horse has already left the barn on the earlier legislation on the wiretapping. I think that committee idea is a bad one. I'll just let you know that. This is the protection of attorney-client privilege is essential to our constitutional government. I think you all know that. The wiretapping and eavesdropping that has taken place around the country is the antithesis of a system that works fairly and justly. I don't understand why it takes a committee to figure out what the constitutional parameters are. I did share with Chair Carney and with Representative Harnett a paper that my law school grandson has written on the subject of wiretapping and the interruption or the interception rather of communications between lawyers and clients. And I'd be happy to share that with the entire committee, but I'll let that go. I just want to suggest to you that it's a bad idea. Now, I was privileged to chair that December 9th committee hearing that we had, and let me cut to the chase on that. If you were to summarize what was said by the participants on December 9th, you would conclude the following. We have too few qualified lawyers handling too many serious criminal cases. We have a system that is broken. We have a system that imposes on volunteer lawyers burdens that should not be so imposed. There is no parity between the prosecution function and the defense function in the state. So that's a summary of that December 9th hearing. And the bottom line was, of course, that we're not complying with the Sixth Amendment in the state of Maine. And in that context, and I have to be careful because I'm a defendant in the lawsuit in my capacity as a commissioner. The ACLU has brought a lawsuit seeking injunctive relief based upon the state's violation, continuing violation of the Sixth Amendment. I would urge every committee member to read that complaint. With respect to the issues that are before you now, and then I'll turn off my megaphone here. Each and every one of them is important, but each and every one of them is like putting patches on the wheel of a car when the engine isn't working. We need a revised public defender system in this state, a pervasive overhaul of the criminal justice system in the state of Maine. And it's going to come. The ACLU lawsuit's the first step. I won't predict the outcome. I've already spoken to what I believe should be that outcome, but I'm going to restrain myself in that regard. I really appreciate all the efforts that you folks have put into these subjects, only to be frustrated when the proposals that you offer have not been properly funded. I encourage you to continue your work. I do encourage you to read the complaint filed by the ACLU. It should help and guide your decisions going forward. But irrespective of all your good efforts, I'm not sure the system is going to change until the legislature in general and the executive branch in particular understand and welcome the need to comply with the Sixth Amendment of the United States Constitution. Thanks very much. Have a St. Patrick's Day that is joyful and blessed, and continue to do your good work. But I'm somewhat unhappy that we are where we are more than 2 years after the Sixth Amendment Commission, for which we paid hundreds of thousands of dollars, told Maine that it's not complying with the Sixth Amendment, and nothing really substantive has taken place. Thanks very much. It's been a privilege to comment, and I will now leave the scene.
Many thanks to you, Commissioner Cummins. And Robert Ruffner, would you like to address us as well? I'm not able to hear you. I don't know if other committee members are as well. Okay, I think he's trying to return to the panel in a way that we can hear him. While he's fixing that, Robert Cummins, happy birthday and happy St. Patrick's Day. We're going to send you back to the attendee part of the meeting where you'll be able to listen and watch. Thank you.
Thanks very much.
Robert Ruffner, do you want to try talking and see if we can hear you?
Trying. Is this any better?
Yeah, we can hear you loud and clear now. Go ahead.
All right, I won't touch anything for fear of messing it up again. Senator Carney, Representative Harnett, members of the Judiciary Committee, thank you for allowing me to speak to you today. Hopefully you can still hear me.
Yeah, keep
yes,
going.
Okay, great. I hope that the committee will consider recommending that the Appropriations Committee fund the bill that's still on their table for the Public Defender's Office in Kennebec County. I know that the commission has continued to affirm in votes this year that is its a priority in its position that should be funded. I believe that when, and I cannot speak for the executive director because I'm not him and nor am I even an employee, but I believe that the 4 proposals that he rattled off and then provided more information about did not address that initiative because it already existed. It didn't require anything from this committee to do this session. And I think the question was put to him, what do you need? What initiatives do you need us to consider possibly voting on and passing out? And so I believe it's that's why it wasn't specifically mentioned, because it doesn't require it didn't require new legislation because it just requires funding on the appropriations table. I think that all of the initiatives that the executive director has suggested, new ones, are important. I think that he sort of described the flying squad as necessary, but I would characterize it as more of a duct tape type of solution, that it isn't his first choice, but it's really the only tool that he could possibly come up with this session, but it's not the ideal format. So I appreciate you taking that up, but I hope that the committee would stress to the appropriations the desire that they fund the Public Defender's Office in Kennebec County. That, I believe, would be the single biggest step forward in the evolution of indigent defense in Maine. It would not help me at all, but it would, or my employees, but in terms of changing the discussion, in terms of moving the ball forward and innovating how we provide these services, that's really the single biggest initiative. And then Maine would no longer be the only state in the nation that does not have a public defender's office somewhere. And I believe that Attorney Andrus or Director Andrus was clear on the issue of the flying squad wouldn't really be a public defender's office. It'd be a way to staff cases on an ad hoc basis, where needed. It wouldn't be really the same thing that you get all the externalities, the seat at the table, the partner in innovating solutions to problems of society that end up in the criminal justice system, but really they end up there because there's no other place to put them, as opposed to that's the best place to put them. That sort of partner in creative solutions to a whole host of issues is something that we don't have yet in Maine without that office. So I would hope that that we don't lose that possibility this session with the surplus. And if there's any questions, I'd be happy to answer them. But I know that you've got a lot on your plate and need to take this up. And again, I appreciate you allowing me the time to provide some information.
Thank you very much for that additional information and for being here with us today. I think we're going to resume our committee discussion. And so I'm going to send you back to the attendee part of the meeting. Oh, okay, he has deactivated his camera. So committee members, at this point, I think Peggy, I wanted to check in with you about the suggestion that seems like many committee members agree with, that we, at least for purposes of speeding the delivery of the information to the Appropriations Committee, that we draft them up as separate budget initiatives. Can you comment on whether that's doable and any additional things that you feel we need to discuss today to get to that point?
I think it's doable. So, and I think what you're asking is, can I put together kind of all the initiatives that you just went through? I'm not sure about Representative Evangelos's, but and also based on what Mr. Ruffner said, making sure that the Kennebec County Public Defender Office is in your list. So I think I've got, you mentioned 8, Senator Carney, and then Representative Evangelos added the Modified Public Defender Office. I don't know if that's the same as the Kennebec County, or if that is just the idea of creating the Public Defender Office in general.
Okay, let's check in with him. Representative Evangelos?
No, I just wanted to initiate a discussion, Madam Chair, whether we should, as part of the plan next time we meet, stick with just the experiment, the pilot project in Kennebec County, or whether we should, and then obviously the roving team, but whether we should go for something bigger. It's just something we should discuss amongst the priorities. That's all. We'll flesh it all out, with the help of Mr. Andrus as well. But I want it on the table for discussion whether we should go bigger or not. And I would like to hear at some point from Representative Harnett about it. He has a lot of knowledge in that area.
Okay. Thanks. I did want to ask Peggy, and this is something that I've been concerned about, mostly because I've been part of other conversations in other committees related to, like, how do we incentivize people returning to Maine? How do we provide student debt relief? And what are the limits to what we can do given, where those loans come from and whether they're federal loans and stuff like that. And so I know that student debt relief is a really complex issue, and probably because we don't even know how we would try to accomplish that, it's going to be hard to put a dollar amount on that. And then I think the same thing maybe could be said for the health insurance. And so that's something that I can look into over the next couple of days. I know it would be impossible at this point for us to put a dollar amount on that, but so if you want to just for now put a placeholder in the report back, and I'll see if I can figure out some way to accomplish that.
Right. And one of the ideas about covering health insurance and covering the student loan debt is to make them employees of the state, basically. So there is a federal student loan forgiveness program after 10 years of working in public service. whatever's left can be forgiven, but you actually have to be an employee. You can't be on contract. And the same with health insurance. If you have an entity that provides the health insurance that way, as opposed to, rebates or stipends. Or, I think that was one of the reasons people were looking at creating a public defender office, for those kind of benefit side of it, not just the organizational benefits.
Do you know, Peggy, if the status has to be a full-time employee, either for the student loan or the health?
So the health insurance is not part of the federal program, the public service loan forgiveness program. So I would think that the health insurance would totally depend on who the employer is. If it's the state, there might be some, if you're not full-time, then your coverage, what you pay is prorated, or what the state pays is prorated. I guess I'm not sure how that works. So I think it would totally depend on who the employer is and what they're offering for insurance. And actually, Senator Sanborn can probably tell you all about that.
I was thinking that it was her committee that had been working on some of these. Thank you for that suggestion. Representative Babbage and Evans Evangelist, we're going to just skip to Senator Sanborn for a minute and hear from her on this topic. Go ahead.
Yeah, I think with regard to health insurance, unfortunately, we still are in a world where you kind of have three options for obtaining health insurance under Maine and federal law. One is that you buy it as an individual, not related to your employment. And theoretically, there could be some way that individuals could buy it, through a trade group or a trade organization, but it's usually very cumbersome, and there's quite a lot of regulation for some really good reasons around the ability to do that. The second way you get health insurance is through your employer. And generally speaking, because of rules about fairness, you would have to work 30 hours a week or more for an employer in order to be eligible for health insurance. It's possible to have some plans that are at 20, and I don't know what the state plan's limit is, but it's generally only provided to employees who work above a certain number of hours each week on average. And then there's a way you can lose your health insurance if you don't work that many hours for your private employer.
So
and then the
can I
third way
would interrupt? So there are two steps. You have to have employee status, and it has to probably be about 30 hours a week. Okay, thank you.
Certainly, in order to qualify for most of the private plans that I've been aware of for small businesses, it's that the state has somewhat more flexibility because the state is self-insured for health insurance. So they can pretty much do whatever we want to authorize them to do by statute. But there are some rules, and again, these may not apply to the state, but with regard to fairness, right? You would have to offer, if you changed it so that indigent defenders or defenders of indigent individuals, we don't want our defenders to actually also be indigent. I think that's the whole point. If we were to change it so that they would be eligible at a very low threshold, there would be some equity issues that may even offend state law or federal law that would be very difficult to overcome. And then the third way is that you qualify for main care or another type of government insurance program based on either your age, disability, or income level. So those are really the only ways to get health insurance. And so unfortunately, we still have a very employer-based system in the United States. And as a result, I think that's why it makes sense to do things like hire folks that are on staff, either through a public defender office pilot model, like we have on the table with Kennebec County, or the flying squad, I think is the idea is those would be employees who could be deployed, and they would be able to obtain benefits But it's going to be very, very difficult to get benefits out to a panel of independent contractors. There's just not a paradigm for that in the United States, other than through the marketplace, the individual marketplace, where they can go on and buy their insurance for themselves, and then their contract could subsidize that, but it would not be a tax advantaged sort of subsidy. It would just be additional taxable income. The federal government would not recognize it as benefits payments that are tax advantaged from a payroll perspective.
Thank you. And again, I'm jumping around a little bit, but Representative Evangelos had asked Representative Harnett to comment on something. Are you prepared? I know I'm putting you on the spot, but can you comment?
I'm not exactly, I did hear, I did hear Representative Evangelos pose a question to me, and I hope that I have it right. So let me know if I'm missing something, Representative. We have a proposal that is in AFA to do a geographically limited public defender office. And I think that needs to be something that stays as it is, that we advocate for in appropriations. What I think I was hearing you say is, do we also do something larger than that? Other issues, other topics we had discussed in the past was one, an appellate public defender office. I don't know if that was what you were talking about, or are you proposing a statewide public defender office? And I know my recollection from hearing from the commission is that they see, there are commission members that see the need for a public defender's office, but primarily they talk about a hybrid setup where we might have public defenders, but we still have rostered attorneys. So I'm not exactly, I think the committee is free to discuss all of those options. I guess I'm not sure exactly what the question was to me.
I was just, you had mentioned the shortcomings of that we weren't going to get there to fix all the support services and equal the playing field until we truly adopted a public defender system. So I was just tapping into what your vision was of what that would look like, but we're going to be taking things up.
Yeah, I think one of the benefits, I'm sorry.
If we collectively decide it should be something bigger, good enough. I just wanted to know if that was something you thinking we were moving forward to.
I think one of the benefits of establishing any type of public defender office is that it allows us to address the problems of support, of health insurance, of loan forgiveness. So there are a lot of reasons to pursue that model, because we can address so many of the concerns that we heard about at the December 9th meeting. So certainly something to be discussed. I hope that.
Thank you, Madam Chair. My phone's ringing. The only other thing I wanted Peggy to look at was check out the veterinarian example and see if it's true and how it works, and report back to us.
Yeah, I'd forgotten about that. Thank you for reminding us.
Sorry about the interference there. It's
okay.
My 1950s phone going off.
Representative Babbage, you've been waiting a while. Go ahead, and thank you for your patience.
Thank you. Thank you very much, Madam Chair. Well, I would like to weigh in. First, I think the Public Defender's Office is extremely important. We need to express support in some way. I am not sure about the timing of that. I want Mr. Andrus to be very effective in his implementation of change. I know he thought the Kennebec County office would be perhaps more convenient for him to work with and oversee in part, I think. With regard to, so I'm saying that should remain and that is where we need to go. There's no doubt about it. And I think the hybrid system is hopefully where we'll end up. But that is going to be a major commitment of money that the state will need to make. with regard to health benefits and student loan forgiveness and things of that sort that are incentives, even to a lesser degree, the legal research materials, with part-time rostered attorneys, I think that it is problematic. The research materials, the $700 an attorney is essential. It's almost an incidental expense at $230,000.
Representative Babbage?
Yes.
I just, I'm interrupting you just for a moment because this sounds like a good conversation for our next meeting, although if you want to continue, that's fine as well.
I'd just like to express a priority if I could.
Okay, go ahead.
The priority that I would have here are not only the four, I'm not sure how we're labeling them, but the four priorities of Mr. Andrus. But I think we need to make an expression as a committee of financial support for indigent legal services. And I would say, rather than address health benefits and student loan forgiveness and things of that sort, that we should address the hourly rate and propose something like $120 hourly rate, which would, the last I heard, I thought $100 was the minimum among other states, other than our own. But $120 hourly rate would probably mean an increase of $10 million. And if AFA decides to pare that down, then so be it. But the reason we need to start getting into an 8-figure increase is because we are eventually going to need a $30 or $40 million allocation for a public defender's office and indigent legal services. And so I think by demonstrating support for addressing the needs of indigent legal substantially at this time puts the budget in a better place to get where we need to be over the next 3 to 4 years.
Thank you. All right, committee members, it is 12:30. We've been meeting and had actually, I think, a really helpful discussion. I just wanted to check in with Peggy and see if we're going to frame these up sort of as in language that looks like budget initiatives. What else would you need from us at this time? And can we sort of think about when we might want to resume this conversation, taking into account all of the other committee work that is on our to-do list, although we've made great progress this week.
Great progress, right. Well, I think that we really don't have a whole lot of time. You have session on Tuesday and Thursday. So if you want to meet Monday, Monday at 10 works for me. I don't know if you're going to do this or you're going to do the two bills that you still have to work on, the Rulona bill and the court-ordered treatment bill. And we still haven't seen the errors bill. And I think you will have a couple of freedom of access, the public records reviews coming up. But I think I can have, it might not be, perfect for you on Monday, but I think I can have at least some good working papers for you on Monday that you can go through them and, as starting points, something actually on paper for you. So that means I'll commit to sending them out to you on Sunday.
Okay. Would it be helpful from a kind of global committee workflow issue if we waited on Rulona and the substance use court process until Wednesday?
Sure.
Okay.
Yeah, that would be fine. Thank you. So we can focus on budget on this piece of the budget on Monday. Okay.
Does that work? Yeah. Does that work, committee members? If we finish up our budget work on Monday at 10. And then we take care of our other committee work on Wednesday. All right, I'm seeing lots of nodding heads.
Yeah.
All right, any other comments or thoughts or inspiring statements before we sign out for the day? Okay, I'm not seeing any motion to adjourn. Thank you, Representative Warren. And lots of seconds, so we will adjourn. Thank you very much, everyone. See you Monday at 10. Oh, hang on.
I'm sorry, I couldn't get to my thing fast enough. Did the people that were absent for the first two bills, do they want to vote while we're still on camera? Or do you want me to just go ahead and send out the approvals by email?
You can
I'll
send it
vote.
by email for me.
I'll vote, Supi.
Of course you. Representative Evangelos, is that okay, Madam Chair?
Yes, of course.
That was on two bills, Representative Evangelos. 1946, the motion was ought to pass as amended. I had a 10 in favor, 0 negative, 4 absent. How would you like to be recorded?
I'll vote yes.
Representative Evangelos votes yes. Thank you so much. LD 598, the motion was ought to pass. I have 8 members voting ought to pass, 2 members voting ought not to pass, and 4 members absent. How would you like to vote, Representative Evangelos?
Yes.
Which would be ought to pass?
Yes. I'm sorry. Yes, ought to pass.
No, that's absolutely fine. Thank you very much. I appreciate
you.
it. Thank you, Madam Chair.
Great.
Thank you. And everyone, thank you. I think we are ready to adjourn at this point. Have a nice weekend and see you all on Monday.
Sounds good. Take care.
Thank you.
Thank you all.